Good morning, everyone, and welcome to the Cork Business Association webinar, which focuses largely on SCARP, which is effectively an examiner light for small companies. You're going to hear a lot about it over the next couple of months and years. So I think that there will be some valuable lessons learned from the next 40 minutes. A couple of housekeeping matters. This is being recorded. So note that, and if you do have any questions, please put them in the questions and answers box below. We'll try to get answers to them, and if we can't, we'll contact you directly after the webinar. My name is Dave O'Brien. I am a board member of the Cork Business Association and on the executive committee and finance spokesman for the organisation. I'm also a tax partner with Quintus, where we focus mainly on succession planning and restructuring for corporates, among others. With me today is Tom Murray of Friel Stafford. Tom is a qualified chartered certified accountant. In 2003, he moved into corporate recovery and insolvency, and is now one of Ireland's most experienced corporate recovery and turnaround practitioners. Tom has been engaged by all the major accountancy bodies in Ireland to provide lecturing on insolvency and corporate recovery. And Tom contributes many articles on this subject, as well as appearing on TV and radio, commenting on insolvency. It sounds like Tom doesn't do much else besides talking to microphones, but I'm sure Tom has a vast amount of experience dealing with practical matters, and you will learn a lot from him. Okay. So Tom, before I hand over, I'm just going to have a couple of just points on debt warehousing, just so that everyone is fully aware of the updates to debt warehousing. As everyone knows, the interest rate now is 0, so that has gone down from 3% to 0. However, every company needs to engage with revenue by 1 May 2024. And if you don't engage by that date, there is the possibility that you will be excluded from the debt warehousing scheme, which means the interest rate will go back up to 10%. Now, revenue have indicated that there will be some leeway with regard to this, but that leeway will only be a couple of weeks. So if you haven't engaged with revenue at this point on debt warehousing, please do so as a matter of urgency. When you are talking to them, repayment terms are flexible. We have seen many cases where greater than 5 years has been given on a repayment terms, up to 10 years in some particular cases, and with no down payment. So usually what we would normally see would be a down payment of 25% at least. We're seeing in some cases now that could be at 0. Payment breaks are also available. So please don't be forced into something that you cannot afford. And remember, you need to keep your current taxes up to date. So that has to be kept in mind when you're agreeing a payment plan. Revenue will be issuing a letter sometime this month to all taxpayers within the scheme. And so just make sure that you are reading that letter. Make sure that the debt warehousing agreement is correct, or if you haven't entered into one, that you are engaging with revenue. Your tax advisor will not have received this letter due to GDPR reasons, so please don't ignore it. Debt warehousing goes hand in hand with SCARP, but it is important, again, that you engage with revenue, as revenue have the ability to opt out of any SCARP arrangement, which Tom will go through now. So that's just a very, very quick update of where we are with debt warehousing. So I'm going to hand over to Tom now. We're really fortunate to have Tom on board for the next 40 minutes. So Tom, take it away.
Thanks, Dave, and listen, thank you very much for the invite to yourself and to Cliona, who's helping there just behind the scenes. So thank you very much for the invite, and I look forward to spending the next 40 minutes. Though when I was preparing the slides, I didn't think we'd only 40 minutes, and I've over 40 slides. But listen, delighted to have the opportunity to meet with you and share my experience of SCARP, the process, and just broader general insolvency issues. Very conscious of the time, so I'm speaking quite quickly. I'm going to speak quite quickly, so if I'm talking too fast, just pop it into the chat box. Cliona will keep an eye on it, and she'll tell me to slow down. So listen, what we're going to do is just an overview of a little bit of the background. So, to the SCARP process, a little bit of the issues that are facing people out there at the moment, and just how SCARP really is something that anybody who's looking at insolvency needs to or should consider. And no insolvency practitioner, such as myself, should put a company into liquidation without first considering SCARP. We'd always have the view as a firm that a company should be rescued if it should be rescued. There's jobs depending on it, there's livelihoods. Sometimes, particularly at the SME level, the business is part of the family, should be rescued if it can. And SCARP is another, if you like, tool in the armory of an insolvency practitioner where we can try and keep companies alive. Cliona, if you don't mind, just some of the issues that we're seeing out there at the moment. I think it's fair to say, and just by way of background, Friel Stafford was set up 30 years ago. It's a niche. It was set up as a niche accountancy practice specializing in corporate recovery and solvency. We joined the IFAC group last year. So, we're seeing, we've always been a national firm in the sense that we've looked at companies from, Donegal to Cork and everywhere in between, from a point of view of insolvency and liquidation. But this is, and I'm with the practice 21 years now this year, this is the busiest January and February that I've seen, including post 2008, 2009. We've taken over, I think it's 23, 24 insolvent liquidations this year. We have a number of SCARPs ongoing as well. There is definitely, we've seen since September, October, a change in the atmosphere for a lot of companies in certain sectors. And there's a number of factors contributing to that. Obviously revenue, Dave talked about the extension and the 0% with warehouse, but warehousing is a real issue for companies. And some companies, no matter how well they trade, they're never going to recover back. That legacy debt that's hanging over is not going to, they're not going to make the margins that they're going to generate over a period of 3 to 5 years, whatever it is, to recover from that legacy debt. There's other broader geopolitical issues out there. We've seen rising interest rates over the last couple of years. High inflation, is also having an issue. Like the inflation in the country last year was, I think it was 6%, 7%. Labor shortages, big issue. A lack of bank finance at a certain level and for a certain type of company. Banks' attitude to lending to companies with revenue debt, particularly non-revenue debt, and employee turnover. So for a lot of SME owners, where you're looking after developing business, you're looking after the operations, you're looking after finance, you're looking after HR, you're looking after everything. Very much these owners feel like the rabbit in the headlights. And when they feel they're firefighting different things at different stages, things get on top of them. And the reality is they need to step back. So when you're a director of a company and you're in a situation where things are difficult, the company is perhaps treading water, it may be loss-making or becoming loss-making. There's a number of things there's really 4 channels you can go down. You can quit while you're ahead, and you can, if you may have historical profits that are built up in the business, and that you're saying, well, I've got to a certain stage in life, I'm going to be using the profits and the reserves that are built up to keep a business alive through a period of difficulty. I'm going to roll them away. I tell you what I'm going to do. I'm going to convert all this into cash, and I'm going to liquidate the company solvently and take the money out. Okay. Other companies, sorry, Cliona, if you can just go back up one, is just jumping there. Other companies, what you call it, they may not quite require, they realize the business is stagnating. It's not quite, insolvent, but certainly what they're doing is there's a change in the sector, there's a change in the market sector, the geographical sector, there's a change in their industry. They may need to change what they're doing. They may have to change their operating strategy. They may have to change the business strategy as a whole, and they may look at a turnaround process. And that can be supervised by someone like me, but generally it's not a formal insolvency process. And then you've got situations of companies that are not viable, that but can be made viable, but they have to go through a formal restructuring process. And this is SCARP, which we're here to talk about today, or examinership, which has been around since 1990, and some of you will be aware of. But ultimately what that is that new money comes in, and both SCARP and examinership are situations where new money comes in and you deal with your legacy historical debts. You draw a line in the sand, you pay a percentage to those creditors, and you move on with a solvent balance sheet, with a viable cash flow going forward, and the company with a future, a viable future. or there will be those companies that are not viable going forward. And unfortunately, those companies have to be brought to a responsible end, and then you put them into a creditors voluntary liquidation. And as I say, I think by the end of this week, we'll have 25 insolvent liquidations, unfortunately, that we've had to help companies with in this part of the year. There's a lot of companies out there feeling the measure. And each one of those companies, we would have considered whether they would have been a candidate for SCARP beforehand, because the goal is to see, can we save the business? Can we return it to viability? And can we protect the jobs and protect livelihoods going forward? Cliona, if you don't mind. So just trying to say where you should be looking at, and I like this chart. Really, if you've got a company that it's in financial distress and beyond, it's definitely facing cash flow difficulties. It's going to run out of cash relatively quickly. You've done the projections. You're seeing that this company, it may be solvent on a balance sheet basis, but on a cash flow basis, it's not able to pay its debts as it's fall due. And it has an immediate, if you like, what you call it, cash call or difficulty. You're looking at liquidation, or you're looking at a restructuring either through examinership or SCARP. If it's a situation that you have the short term, less than 12 months, but you have a declining business, it's not going to be sustainable beyond that. You may want to look at an informal turnaround process, but certainly if you've more than 12 months to 2 to 3 years, you can look at a turnaround process. But if it's less than 12 months, you're definitely going to become insolvent or not viable. You should be looking at SCARP / examinership, or looking at a liquidation, because the earlier you look at these things and you look at the options that are available, the better chance as a director of a company you have to turn it around and to improve the situation for the or give yourself more options to turn around.
Hi, Cliona. Dave, just coming in here. Is Tom gone off screen?
He's frozen. It seems his local connection has dropped.
Okay, so I'll just give him a call there just to make sure that he can come back in.
Cool.
I'll just go on mute. So we'll be a couple of minutes. He's gone off, so he's going to rejoin now. So when he rejoins, we'll continue with it.
Folks, I don't know what happened there. I just seem to be thrown out there. Can you hear me now?
We can, Tom.
Yeah,
Thanks.
I
You're
don't know
fine.
what happened there. I'm gone onto a different screen, and the background is
Your
gone.
background's not as fancy, but that's
Yeah,
fine.
that's okay. That's okay. We'll just blur it. Okay, so I'm going to just look at this. Now you're looking at the side of my head because it's gone onto a different screen. I have 3 screens in front of me, and I can't seem to move, and I'm afraid to touch anything in case it disappears. So anyway, so apologies to those who've seen the not so pretty side of my head. So ultimately, Cliona, if we can go on to the next slide, and just tap a couple of times. If you're a solvent company, if you're the director, it's very important to say to directors, just get back to my train of thought, that under the 2014 Companies Act, there is very much a key thing where, obviously, as director of a company, you have a primary fiduciary duty to the company itself. However, once you become aware that you're solvent, or insolvent, or likely to become insolvent, that duty pivots towards a duty to the creditors. So you need to make decisions with the creditors in mind. Okay. And you certainly should not be taking any actions that do not, what you call it, prejudice them in a deliberately adverse way. So if your company's solvent, continue to trade and okay. However, if the company is insolvent, the first question you have to ask yourself is, can you just tap again one more time, Cliona? There should be just a couple of other things. Just tap it another couple of times. Just yeah, thank you. That's perfect. So if you say insolvent, right? Can you return the company to solvency? Well, you sit down with your accountant, you sit down with perhaps an insolvency practitioner such as myself, and the first thing you say to yourself was that if no, you can't, that this company is beyond repair, that it's not a viable business for reasons perhaps outside the control of the directors, well, then you should put the company into liquidation. However, if it's a situation that you believe this company can return to solvency with the assistance of an IP, either through an informal turnaround process or a restructuring process, and then you go to either examinership or SCARP. SCARP was brought in, though, for those companies. Examinership is a very costly, and and it can take it's a significantly time process, well, a longer process than SCARP. SCARP was brought in to bring in a time and cost-effective process to help rescue and save these companies. Cliona, if you wouldn't mind. Thank you. So click again. Thank you. So just a little bit of legislative background. It's been muted for a number of years. Post-pandemic, it was seen that this was going to be a need, particularly with the number of companies that were, facing the challenges arising out of warehousing, arising out of loss of trade for periods of time, that there was going to be a number of companies, and to help stem and stop a need for these companies to go out of business, to go into liquidation, the SCARP process was drafted. And you can see a period from October 2020 up to the 7th of December 2021, it was enacted. There was a significant push to get this through the legislative books. And in fairness to those in government, they did I would say nothing's ever perfect, but they did a good job in drafting the legislation. Cliona, if you don't mind. So what is SCARP? SCARP, effectively, it's a simplified version of examinership, and it's geared specifically towards small and micro enterprises. And ultimately, it's an alternative examinership, because a lot of, you have to remember, we have to remember that in Ireland, we have an SME market. The vast majority of the companies that are in this jurisdiction are SMEs, but a significant amount of those are they're not able to participate in the examinership process because it's too costly and too time consuming. In an examinership process, you have at least 6 sets of professional firms. You need an independent expert accountant to do a report. You need a petitioning solicitor. You need a petitioning barrister. You need an examiner. The examiner will have his own legal team of solicitors and barristers. It can be a very pricey process, and really, even with the best one in the world, you're talking close to 6 figures for most examinerships. So the whole point of SCARP is to save companies, save jobs provided of it in a cost-efficient manner. Cliona, please. So just, you have to be a small or a micro company. Okay, you have to be unable or likely to be unable to pay your debts. You should not already be in liquidation, and you should not have used this process in the previous 5 years. So, SCARP is something that you can do. I'm not saying you're going to do it time and time again, but certainly we will see companies in time who've gone through this process, perhaps going through it again. Cliona. Just in terms of the eligibility criteria, your turnover cannot exceed 12 million euros. Your balance sheet cannot exceed 6 million euros in assets, and you have to have less than 50 employees. So how you go about it is, you obviously recognize that the company's in difficulty. You recognize that the company's not really going to be in a position to continue as it is, and you go to someone like me, an IP, to take advice. And you will ask me to act as what they call a process advisor. So I wear many hats. I'm a liquidator, I'm a receiver, I'm a personal insolvency practitioner for those who need to go bankrupt or do personal insolvencies, and I'm also now an examiner, and I'm now I'm now a process advisor. So the life of an IP can be quite schizophrenic. You have all these different hats and roles that you can take. And ultimately, you have to have the same qualifications as somebody who's under the Companies Act, who can act as a liquidator. And in simple terms, that's you're a qualified accountant or a solicitor, or authorized by a body called IASA. And the key thing here is, one of the key things is, your existing company's accountant or auditor cannot act as a process advisor. So, it takes away a lot of the natural inherent conflicts of interest that there may be there. Thanks, Cliona. So you have a lot of powers as a process advisor. We're entitled to get books and records of the company. The company's existing accountants or solicitors. If I need information to formulate a plan, they cannot hold that back to me. They cannot hold a lien over it. For example, if there's unpaid fees to the accountant, he cannot refuse to give me the books and records to help me put in place a plan to rescue the company. I also have the ability to certify certain liabilities to be treated as an expense for the SCARP. And what this means, these expenses can be treated differently to other liabilities. So, for example, in a SCARP, you're going to pay a dividend on liabilities up to the date that you enter into the process. However, I can say that like instead of paying a dividend, I can certify that some of them are essential and they get a higher dividend than the other creditors, so I can treat them differently, certain, and I have that power to determine what they are or not. Clean up. So effectively, how a company will go through the process is the director of the company will prepare a statement of affairs by statute declaration. So they will prepare the statement of affairs. It's very important. It's done by statute declaration. There's implications for doing a false one, but it has to, and that is then submitted to me as the process advisor. I will then gather certain information. I will meet with the directors to discuss, and I'll give them an informal report on whether, in my opinion, the company has a reasonable prospect of survival. When I say it's informal, I'm not technically appointed as the process advisor at this stage. That's why it's an informal report. So I'll write to the director saying, based on the information, the work that I've done, I believe that this company has a reasonable prospect of survival, subject to doing a SCARP, and in that SCARP, X, Y, and Z, investment of X coming in and paying a dividend of X, Y, and Z to the creditors. And what happen then is the directors will consider that, and the board will then pass a resolution to formally commence the process and appoint me as or another IP as the process advisor. They'll pass a second resolution where they will cease all payments to creditors, i.e. we're going to pay nobody for the duration of the process. And this can all be done fairly quickly and quite cheaply, in the sense that there's no application to court, you've no solicitor's fees, no barrister's fees. It's the process advisor working with the directors on it, and that so in fact in many cases no costs, no professional fees are undertaken. Clean up, please. So I have to determine, whether the company has a reasonable prospect of survival. So once I issue my informal, inverted commas, report to them, they have to convene a board meeting and formally appoint me if they're going ahead. Otherwise, we have to go back and start the process again. Clean it, thanks. So effectively what they do is, once they pass those resolutions, we then go straight down to the relevant court. We notify all the creditors. The resolution is also delivered to the CRO, and it's advertised in Ur which is the government publication, and the company's website. Okay. The creditors will receive a copy of the statement of swears that was made by the directors of the company, and they'll receive a copy of my process advisor's report saying that I believe that the company has a reasonable prospect of survival. They'll also receive a proof of debt form, which needs to be sent back within 14 days. And effectively then, we will start formulating a scheme of arrangement and a plan for the creditors of the company, which will be for the shareholders and the creditors of the company, which will be put to them. Now, the creditors will have an opportunity to engage with the process advisor. They can send comments into them, or they can ask questions at that stage, and they can disclose any facts which they believe are material to the process. Clean it. Thank you. So I'll do a report. My report will be like what the independent experts report for the examinership. I'll say whether I understand where the deficiency has arisen from. I'll give an opinion as to whether the company has a reasonable prospect of survival. I will make recommendations as to what course the company should take. I will give details of any of the funding required. And I will make a recommendation as to what pre-petition. This is where it comes back to the point about certifying expenses that need to be paid. I'll also have to give a view on what my proposed fees will want to be. Now, I'd asterisk that is an issue just that a number of the regulators have, that a number of the SCARPs that have taken place today in the country have been quite expensive. And it is certainly a view, having to have formal and informal discussions with certain regulators and the revenue commissioners, that they feel sometimes some of the SCARPs fees have been quite chunky compared to what they want to be. And we can come back to that later on. Sorry, Cleena. So I will then, with my team, or any other IP process advisor, will work on a rescue plan. It'll include the statement of affairs. We'll do, and one of the key things is we will compare where the company, what the rescue plan, what it'll do for the creditors and for the company, and compare that to the equivalent on a winding up and or receivership. We'll explain what the effect of the plan is. We'll explain why we believe this is equitable and why this is a better option both for the company and for the creditors and for the shareholders. And I'll also then come fully clean as to what the remuneration and the pay of the process advisor is going to be. Now, during that process, we will consult with various stakeholders, including directors, the shareholders and creditors. And ultimately, I'm trying to achieve an agreement between the company and its creditors to settle the debts. Now, let's be honest, there will be pain for shareholders. There could be pain for certain creditor class, or sorry, shareholder classes. But ultimately, what we're trying to do is we're trying to get something which is better than the alternative, which is liquidation, where people lose their jobs, a business is gone, and effectively creditors are burnt fully. So ultimately, when we have to make sure that no creditor, though, is unfairly prejudiced. Everybody has to do at least as well as they would as in a liquidation scenario, and they would, like, people of the same class are not prejudiced in relation to each other. And this is and ultimately, if I can't satisfy that best interest of creditors test, i.e., better outcome than liquidation, this automatically fails at the first hurdle. Please. So what can I do? Well, I'll be writing down debts. I can break those debts into different classes of creditors, and I can give different classes of creditors different treatment. So, for example, there will be unsecured creditors. There may be important retained creditors that the company requires to go do business with going forward. There'll be floating charge creditors. There'll be preferential creditors. So we can do different dividends and different plans for different outcomes for different classes of creditors, as long as it's always better than what they get in a liquidation. In examinerships, generally, okay, there's always an exception to the rule. You settle creditors with a bullet or a lump sum payment. With SCARP, it can be a situation that you're paid over a period of maybe 2-3 years, for example, that certain things that are predicted to happen into the future would produce a further dividend that the creditors can take an advantage of. It may involve new investment from current or new shareholders, and it may involve the dilution of existing shareholders. I'm working on one large one at the moment where there's substantial investment coming in from new shareholders, where it will involve the dilution of the existing shareholders and it'll have their support. Sorry, cleanly, yeah, thank you. But I have to be very clear for the creditors who will and who will not be impaired, and the impact of each of the class of creditors, and everybody has to be fully aware where they stand and how they are treated in relation to everybody else. Cliona, thanks. Okay, what about landlords? Well, you can suggest a reduction of rents. This is where it gets a little bit tricky, but you can only do that with landlord consent. It may be possible for a company working in different jurisdictions that you may look to repudiate property leases if, and I'm certain that it's necessary for the company's survival. However, this is where it gets expensive, because one of the advantages of SCARP is we're trying to keep it that it's a little bit more cost effective by keeping out of court. But if you need to go for a repudiation of a lease, you will have to go to court, and that will make the process expensive by tens of thousands, in the sense that you don't walk into the court without spending 10,000 euros generally. And what will happen then is that the landlord's claim will then become an unsecured for the remaining term of the lease, let any mitigating rent that may be received. So that could be a substantial creditor. Revenue commissioners, and this is very important, or other state debtors. It is an excludable debt, and this is a new thing in the whole concept of corporate insolvency, and it's borrowed from the extent of personal insolvency legislation we have. But in effect, revenue and other state creditors are an excludable debt, and they will only be included in the proposal. They have an opportunity to opt out, is what I'm trying to say simply, in that they have 14 days where they can say, we're not actually going to participate and you cannot write our debt down. Now, they have to have solid grounds for not participating. Tax returns may be outstanding. There may be an ongoing tax audit and intervention. There may be taxes under appeal, non-compliance, and other grounds. But if you've been a good taxpayer, you've been hit by COVID, you've put stuff into warehousing, you've been complying with keeping your current taxes up to date, they will participate. It's where you've had a history of acting, being difficult for revenue in terms of tax compliance, then they're less likely to opt in. Okay, and in that case, they will be outside the scheme. That doesn't mean a SCARP won't work, but it means that you're only dealing with the other classes of creditors, and that you'll still be fully on the hook for the revenue debt. Cliona, please. So we have to put the rescue plan to the creditors. So at the latest, they'll get a notice of a meeting by day 42. The notices will be sent by email, because you have to give them 7 days notice for the meeting. So the last day, the plan has to be approved or not approved by day 49. And we need to have 60% majority in number and a simple majority in value in at least one class of creditor. Okay, and if that one class of creditor votes in favor of the rescue plan, it is binding on all creditors. So quite frankly, you know, in many SCARPs, it's possible to get that one class of creditor, because you have different classes, and you'll find one class will support it. And effectively what happens then is, if one class vote in favor, the plan is approved, and the creditors have 21 days notice to file an objection, okay, to object to it. If there's no objection to the plan, there's no requirement to get court approval. It's passed, and we file the necessary documents in the CRO. Cleaner, thanks. And it becomes statutory. It comes binding 7 days after the statutory notice is filed, unless objected to within that 21 days. Cleaner. So why would somebody object? Well, they can file a notice of objection with the process advisor and the court. They have to do, and the court will sanction the plan unless the objector can show that it was unfair and inequitable, or unfairly prejudices them. Okay, so in other words, effectively, they'd have to show that that they've done better in a liquidation, in simple terms, and to actually succeed, in my view, in an objection. If the IP does its job right and prepares a plan that has a better outcome for the individual who's objecting than they would have got in a liquidation, it's hard to see how they could succeed with an objection. Cleaner. However, there may have to be some, the other grounds where they can object is that there may be some material irregularity in relation to the convening of the meetings. They didn't get the proper 7 days notice. They didn't get the full paperwork for the meeting. There has to be either a structural error on behalf of the IP in calling the meeting or in the providing of notice, or it has to be that they get better in a liquidation scenario. Apart from that, there's no reason, unless it's done for fraudulent or improper purposes. Okay, thank you, Tlina. So if you want to consider for your business a SCARP, I would say start working on a statement of affairs. Start working on cash flows that show what is required to make this company solvent, okay, or viable on an ongoing basis. Link in with an experienced insolvency practitioner who will work with you on this with a view to appointing them as your process advisor. Then the process advisor will issue his report. Within 7 days, you will appoint him, and then that is day one of the SCARP process. And the IP will go to work. It's quite an intensive process. They start the preparation of the SCARP, including engaging with the excludable creditors, i.e. the revenue. You will then ultimately, at some stage in the first 42 days, you'll have prepared your plan, and you'll send out the notices and a copy of the plan to the creditors with a view to getting approval of that within that 7-day period. Within that, assuming that it's approved, should be, and within the next 21 days, days 49 to 70, there's a cooling off period, and if there's been no objection in that period, then the thing is approved, the SCARP is approved, no further notice, documents filed in the CRO, and the SCARP is completed. Clean up, please. So very punchy, and what I like about it is, if you're a business owner, and we all know how stressful it is when a company's particularly facing insolvency, etc. Fairly quickly whether this is going to survive or not, okay, or whether it's going to succeed. From the moment you meet the IP, a couple of weeks to the almost appointing him as the process advisor, him issuing the report, and then the 49-day process with the 21 days, you're talking with 2.5 months door to door, from first meeting till being out the gap, okay, unless there's an objection. It's a very quick, punchy process. However, one of the key downsides is, unlike examinership, you don't have the protection from creditors. So in examinership, you go into court, you get the protection of the court during the examinership process, and no creditors can take any action against you. However, they can in a SCARP. You do not have protection from the court. Now, as a process advisor, I can apply to court looking for protection from a certain creditor. However, that's timely and costly. It costs money to go to court for everything, Cleena. So where does the court come? Really, the court should only have a role in a SCARP in 5 things. If, for example, there's something that the process advisor is concerned about, okay, that it's a legal issue, he may need to go to court to get clarification from court on it. Highly unlikely or at all. If there's a receiver, provisional liquidator appointed, he may want to go to court to get that individual stood down. If there's an owner's contract, such as a lease, he may want to go to court to get that repudiated. He may want to grant protection from certain creditors similar to examinership. He can go to court and apply for that, but it doesn't automatically come. Or if after during the 21-day cooling notice, there is an objection from a creditor, the court will hear those objections made by the creditors and perhaps will overturn the rescue plan. But as I say, I want to be a technical flaw, or want to be done from proper means to exclude tax, or you're not treating them better than they would in a liquidation. Cleena, thanks. So just quickly, and I'm conscious I'm nearly out of breath talking so fast. I hope I'm not going too far, but I'm very conscious of the time. What's the difference between SCARP and examinership? Well, the first thing, substantial difference in terms of costs. Okay. Now, I know certain IPs and colleagues of mine in the IP profession have the view that it's similar work, but the reality is you're not involving the court. It's a quicker process. The costs should be significantly less. There's no size restrictions on examinership apart from cost restrictions, but SCARP, you have to be a smaller micro company. SCARP it's initiated by the directors to pass a resolution. Examinership, you need to go to court. More difficult to bind state creditors into SCARP, no problem. Revenue are part of it. They can't exclude themselves from an examinership process. No automatic stay in court proceedings taken against the company in SCARP. There's an automatic stay. You have the protection of the court in examinership. 42 days in a SCARP. Apologies, it says 150 days there for examinership. It's actually 100 because that was the COVID thing. So that has been brought back down to 70 days, which can be extended to 110. In SCARP, you need 6% in number and 50% plus 1 in value, required for one class and creditor, where in examinership, you just need the 50% plus 1 in both number and value from one class of creditor. ODC may require a process advisor in a SCARP to restrict the directors. Examiner has none of those powers. It's an unusual power in a SCARP. Process advisors are unlikely to advertise their investor given the time, so the directors are more likely to keep control of their business. Or in examinership, there's always the problem that somebody may come in and bid more for your business and take you out of it. If approved by the creditors, no court approval required in SCARP. Again, we're always in front of the court. In examinership, has to be approved by the court. SCARP, significantly lower costs in my view. I'm seeing SCARPs done from 15 to 25 to 30,000 euros. I've seen some practitioners do them for 80, 90,000, but the reality is I've seen SCARPs done for 15k, 25k being the average. Examinership, you're talking 100 grand. I think once in 20 years I've seen fees be less than 100 grand in examinership for everybody all in. Okay, please clean up. So what if it doesn't happen? What if it fails? Well, we have to report to the board why it was not successful and set out recommendations as the next step. If the SCARP was not successful because the state creditors did not opt in, then the examinership might be considered. If it fails over SCARP, SCARP fails over the revenue being so sizable and not opting in, well, then you can go to and do a SCARP, do an examinership, and they have to participate in that. And then if you get a different class of creditor, it can succeed. They can be crammed in. Now, the revenue can always object and drag you through the courts, but generally speaking, they can be they don't have the excludable status that they do have in a SCARP. Cleena, please. Cost remuneration of the process advisor, similar to examinership in that it's paid from the assets of the company. However, you're expected to reduce your costs, and you're expected to use the services of the staff of the company as far as possible. Next one. If I believe the director or shareholder have been guilty of any offence, I do have a duty to report it to the DPB and the the Corporate Enforcement Agency. They've changed. I'm still old school. I still call them ODC, but we do have to report to them. The advantages: you should be able to save jobs. It's much costlier than examinership. You'll definitely cram down liabilities if you succeed. should get a better outcome for the creditors. You have to, than you would in a liquidation. Short time frame. You can repudiate, albeit with a trip to court, onerous contracts, and it caters for the state debt. However, the negatives, if it's not agreed, generally liquidation becomes inevitable. There might be an objection by a creditor, which could trigger an automatic obligation to seek court approval, resulting in higher costs. It may impact the credit rating of the company. It will be, prominent on CRO that you've entered into it. And this is important for those directors out there. It may be a situation that if you're a director of a company and revenue do opt in and there is a write-off of revenue debt, you may be personally liable for PYE that was deducted from your salaries and which is written off in the process. If you're a connected director, that is that you're a director with more than 5% of the share capital of the company, or etc. So you may be liable as a director of that company for any unpaid POI on your salary. And furthermore, any personal guarantees that you've given to any banks, etc., that are written off, or suppliers that are written off, those personal guarantees may also still be liable. Clean please. There may also be a situation where banks look to set off accounts upon receipt of a SCARP notice. The IP has to be on top of that to try and make sure that that doesn't happen. Now, there is often in contracts set rights to set off that you can do nothing about. A big issue for revenue is a lot of their debt, which is warehouse, is no longer preferential, so it's fallen down into unsecured. And revenue, obviously, that is a financial cost to revenue, so they will look very closely. And if there is a grounds for it being excluded from it, they will exclude themselves, because they possibly will get a higher amount of money in a liquidation, scenario. So some process advisors, if they believe they can argue that it's preferential. Some process advisors may possibly work with invoice discounters to try and obtain funding during the SCARP process. So that's something we're seeing, that a lot of the invoice discounters are looking to get involved, and a lot of the SME equity providers looking to get involved in the SCARP process. Thanks. We should be nearly there, folks. What should you be doing now to take avail of SCARP? Well, I would start, if you feel that the company is not going to be viable, that but can be returned to a viable status, I'd make sure that you have put together a pack, brief history of the company, org chart, who's working in it, what they're earning, summary of any leases, property and finance leases, details of employee salaries, employment history, creditors, a spreadsheet with the creditors listing with the balances owed to them, including their postal and email addresses, prepare cash flow forecasts and trading forecasts, prepare a statement of affairs, and a list of which creditors are entitled to ROT, and prepare current stock listing. That will be very helpful day one when you meet the IP and the process advisor. And then obviously work with somebody who's done the stance. And I would refuse to put new monies into it. Ideally, wait for the SCARP process, as new monies can be very persuasive to creditors. Thanks, Clina. Other issues, just to remind you, your current company candidate or auditor cannot act. You will need to put it on your website that you are going into a SCARP process. The notices can be sent by email. Process advisor fees have preferential status and remain open to review for 21 days post-approval. So if you're not happy with what the process advisor is charging, you can challenge it for up to 21 days as a credit post thing. And again, I can't say this enough to directors of companies, your personal guarantees are going to remain in place, and also the fact that you may be on the hook for the revenue. Clina. So what happens then if it doesn't happen, if it fails? Well, you may decide to go in, because in exceptional cases, to court straight away to appoint a provisional liquidator, because you're trying to protect a trade or something that may be possibly to be sold, or you'll go in as a creditor's voluntary liquidation. You will cease operations and you'll call a creditors meeting. I'll take a breath. That's the slides. I don't know whether that was too quickly, or whether that, whether you have any questions arising out of that, Dave, or maybe some of the participants.
Yeah, thanks, Tom. No, that was great. Thanks a million for going through it and so quickly. I have a couple of questions here that I'll just throw to you, and we'll see what you think. Because revenue can opt out, is there any benefit in going to revenue before you enter into this, to see will they come on board to avoid wasting time?
Yes, there is possibility. Now, there's two things to say to that. One, I will say to anybody who's, sorry, I've managed to switch screens there. I'll say to anybody who's looking to it's gone back on me again. I'll say to anybody who's considering going into a SCARP, we'll look at their revenue situation and we'll say to them whether it's likely or not likely that revenue are going to participate, right? So, you know what, for those companies that are 9 out of 10 companies that are going to go into SCARP, we'll have a clear idea whether they're going to participate or not, right? In terms of talking to revenue, yes, you can always give a view, go and get a view from them, but a good experienced IP will know generally whether they're going to play ball or not, you know?
Yeah, okay.
Okay.
With regard to investment, so the company will need new investment, and usually that will come, I assume, from the existing shareholders.
Well, not in all cases. Okay, generally, again, most of these companies, you'll find that the existing investors will raise money personally, perhaps, and put it in by way of new investments, or bring in other like-minded individuals to support the business. They may have already, I talked to people about putting money into the business and have them lined up. Okay. It may also be a situation, and we've done it before, where there'll be a SCARP where actually there might be surplus assets in the business that can be sold, you know, that kind of way. And it may be a situation that certain debtors are ring-fenced to pay a dividend that doesn't affect the working capital of the business when it doesn't have these legacy debts. So it is possible to do without new investment, but it's a lot easier when there's new money coming in to persuade creditors that this is money that's not on the table in a liquidation scenario, to persuade them to support it going forward.
And that doesn't have to be a certain amount or anything.
Well, it has to be, yes, it has, the deal that you're offering has to beat what they get in a liquidation scenario. Okay,
so that's the level.
That's the level. So effectively, what I'd be, one of the earliest tasks I'd be doing when I meet somebody is I say, really, what's this likely going to generate in a liquidation? And like, I've been appointed to well over 1,500 companies as a liquidator, but between solvent and examinerships and receiverships and all that, I know what the likes of you go to an experienced auction house like Wilson's are going to get for plant and machinery. We get a very clear view on that. We know it because we're selling stuff all the time. We know, that kind of I know what it's like to collect debts in the construction sector. I know what it's like to collect debts in the retail, and like I've sold everything, that kind of way. So we'll be able to speak with a level of experience and authority as to what a liquidation outcome is going to be like. And quite frankly, in many cases, the liquidation fees will be higher than the SCARP fees. This is a punchy in and out 40-day process. The fees for many sizable companies will be a lot less than the liquidation fees. So that's the basic calculation of what money has to come in.
Okay. And you mentioned, I think, like there is a possibility that shareholders could lose control here if someone comes in with an amount of money to rescue this.
Yeah, well, certainly in examinership, that's a very distinct possibility. It's less likely in a SCARP because in many cases, the process advisor won't have the time to go through a proper process. Okay, in terms he may look for investment, but by the time like when you have 42 days to so go out there, get investment, go into a plan. Okay, get investment, go into formulate a rescue plan, put it to the creditors, get approval, and get it all done within 49 days, having given 7 days notice. Okay, so for the vast majority of these companies, there will not be third-party money coming into it. Yes, SCARPs have happened where, it's in a hot sector, or it's like I'm aware in the food, sector where there's been venture capital money has gone into companies where the original people, alongside the original owners actually, but venture capital money has gone into it. So it is possible to bring, outside investors in, but it'll be at a price, that kind of way, because of this level of risk because remember, you're going into a company, yes, that the balance sheet is going to be cleaned up, so you're de-risking to a certain degree, but your due diligence is really limited to the rescue plan, in that period of time. So in my experience, there was 33 SCARPs in the country last year. Okay, and of the SCARPs that I'm involved, it tends to be related party money that's gone into it, but that's not to say that third party money can't come in, and it is possible that the regional owners will be gone. Okay.
Last question from me, I suppose, is there'll be certain creditors, especially in the hospitality sector, if you take Diageo, right, who you're getting your Guinness from Diageo. You can't get it from anywhere else. Is it possible to treat certain creditors completely different than other creditors?
Yes.
So, 100% you're going to Diageo, we're going to pay you, but someone else, you might only get 10% of what they're due.
Well, first of all, I'm surprised you mentioned Guinness being from Cork, but that's okay. But aside from that, yes, in theory, yes. Sorry, not in theory. In fact, I can certify. I mentioned the word certify earlier on. I can certify certain creditors as being essential, okay, and to the running of the company that they get paid. They maybe get paid in full, or they get paid higher than the other creditors to protect the company, to ensure the company's viability, because the company would not be viable without their product or service.
Okay. And how does that go down then with someone like state creditors, let's say revenue, for instance, that
revenue,
someone will get 100% and revenue may not?
I have to be fair to revenue, okay? Revenue, if you've been a compliant taxpayer who is facing and required to go into SCARP by virtue of unfortunate circumstances such as, COVID impacting the business you warehouse it, and it's a legacy debt, but you've kept your filings up to date and you've kept current tax good, and this is legacy, you're not going to. Revenue tend to understand and work with you, okay? How do they feel a certain credits? Well, I think the alternative, it's a simple maths equation. What will they get in a liquidation versus what are they going to get in this process? And if revenue are coming out ahead of the game and it's a compliant taxpayer, they are treating, they're giving it full and proper consideration. And in my experience, are opting in. Okay. If it's a situation that you're an absolute, unreliable taxpayer in terms of your filings and your attitude to them, they're more likely than not to opt out, and they've grounds to opt out. But they will support viable companies, and they will support like essential creditors. They'll be understanding in that regard.
Okay. Tom, that's great.
Okay.
Much appreciated for coming on
No
here
problem.
and talking to us Corkonians. Thanks
No
for everyone
problem.
for attending. The recording will be sent out. And then if you have any questions, please come back to Cliona in the Cork Business Association, and she will direct the questions to myself and Tom, and we'll get back to you. So
Okay.
thanks a million.
Well, Dave, just thank you again, and to Cliona and to everybody. It's been much appreciated, and thank you for the opportunity. Okay.
Thanks, Tom. See you.
Thanks, Dave. Cheers. Bye-bye.
Bye-bye.